Okay, I need to understand at this point who is here, because the process that I understood isn't exactly where we are. You all joined long before my knowing you were going to be joining. So let me begin by indicating that this is case 20-0000053, Eric Ostergen and Jason Gilman Jr. versus Governor Gretchen Whitmer, please excuse me. First of all, can I, for the record, identify the court reporter?
Yes, my name is Laura Steenberg.
Okay. In order for Ms. Steenberg to accomplish her task, we need to agree to the following. First, that all microphones other than mine will be muted except when you are speaking. Can we agree to that? Okay.
Yes.
If at any point in time, Ms. Steenberg has a challenge in hearing or understanding what someone is saying, because the microphone goes in and out, because of any technical problems, she's gonna immediately tell us, and whomever it is will have the opportunity to reiterate whatever they said. Can we agree with that? Okay. With that, this is a hearing on a motion for a preliminary injunction. Counsel, would you please state your appearances for the record?
Yes, good morning, Your Honor. Philip Ellison appearing on behalf of both plaintiffs, but of course this case has just one plaintiff as the move on for purposes of this motion. I would note for the record, Mr. Ostergen is in my office with me, sitting right here off camera. Mr. Gilman is available, I believe I can't see him here right now, but I believe he is appearing by electronic appearance as well in the watching room of this system.
And good morning, Your Honor. Kyla Barranco on behalf of the governor and the state of Michigan.
Thank you. Mr. Ellison, if you would make whatever arguments you deem appropriate in support of your motion for injunctive relief.
Yes, thank you. Good morning. Your Honor, Assistant Attorney General and I had yesterday had further conversations, and we'd like to narrow the motion with the agreement of both counsel. I raised and you ordered yesterday the denial of the supplement of the complaint by the Michigan legislature. I do have some concerns about the Assistant Attorney General appearing on behalf of the state of Michigan when there's different branches who are at odds with each other. So for purposes of today's motion, I would like to amend it to be able to just be seeking a preliminary injunction against defendant Governor Whitmer for purposes of this hearing today only going forward. It doesn't change any of the substantive arguments. It just changes who the preliminary injunction is sought against at this point. I spoke with the Assistant Attorney General and she can confirm.
I do not understand that at all.
You don't understand my words or the argument? You can't audio hear me, or you can't hear me? I don't understand what I'm getting at.
When you said that you had a concern about the AG, and I addressed that in my order, saying if you think you need to DQ or whatever you need to do that directly, not by innuendo. But more importantly, what I heard you say is you agreed you would narrow the focus as to against whom the injunction is sought. So if I don't understand against whom you are now seeking an injunction. You sought it against the state of Michigan and the governor. Against whom are you seeking it now?
Just the governor for today's purposes, for the motion today alone.
Is that your stipulation on behalf of the state of Michigan and the governor?
Not necessarily, Your Honor. Counsel and I did speak yesterday and he gave me this proposal and I said that I would work it up the chain and I never got back to him on it. I guess my only issue with this is that I still don't quite understand Mr. Ellison's argument that, I'm somehow unable to represent both the state of Michigan and the governor because it's my position that those things are pretty much duplicative in the same exact thing. So to the extent that Mr. Ellison wants to orally amend his motion, I suppose I won't take a position with it and I won't object to it, and I'll leave it in this court's discretion.
So, counsel, if I understand you, Mr. Ellison, you wish to dismiss your request for injunctive relief against the state of Michigan. Is that correct?
For purposes of a preliminary injunction, yes, go for today's purposes only. Not as to the whole entire case.
Counsel, respectfully, I'm going to decline to do that. You requested injunctive relief. In order for it to be effective, it would have to be injunctive relief as relates to both entities for the purposes of both the issuance and the implementation of a certain executive order. So we'll go forward on your prayer for relief, and I assume you'll begin with the issue of whether you have a substantial likelihood of success on the merits.
I would, Your Honor. And Your Honor, I appreciate your ruling, and I do reserve an objection on that for appellate purposes, just to make the record clear. Your Honor, the issue today is before you is that, and I agree with and I start by saying the state and I do not disagree with the opening statement in their response brief, which it is well settled that a state, and that becomes the question today, is a state in times of public health crisis may reasonably restrict the rights of individuals in order to secure the safety of the community. The question today, though, is the governor the state? The state of Michigan, by its constitution enacted by its people back in 1963, after that convention, established that the state is divided up into essentially three agency relationships. There's the legislature, who legislates, the governor, who executes the laws, and of course the judiciary that interprets the law. The problem here today that we're asserting in the context solely of Executive Order 2020-38 is that the governor does not have the legal authority to amend the FOIA statute to be able to limit its legislative and statutory objectives. The three laws that the governor has pointed out as being a basis for her arguments, or for her power, arguments for her power, is Article 5, Section 1 of the Michigan Constitution, which does not speak to or otherwise give any sort of power to the governor to suspend or otherwise change positive statutory law. That changing the law, the statutory law, belongs to the legislative branch of government. So it's our position, as we've also outlined in our briefs, that the governor does not have any such authority under the Michigan Constitution. The other two assertions, which I think make up the meat and potatoes of the arguments presented by the Assistant Attorney General's or by the Attorney General's office on behalf of these two defendants, is that the governor has the authority under the Emergency Management Act as well as the Emergency Powers of Governors Acts. Both of those do not provide the governor authority to act in this respect. Respectfully, as to the Emergency Management Act, the Emergency Management Act has a ticking time clock on it, that from the dates of the declaration of emergency or disaster, the governor has certain powers that she's been authorized to activate for 28 days, unless extended by the governor thereafter. Or excuse me, I misspoke, unless extended by the legislature thereafter, excuse me. As a result of the COVID-19 pandemic, the legislature granted an extension until April 30th and did not extend it any further. So the Emergency Management Act does not provide the governor the authority, and the powers that she would have to exercise under that act have terminated as of April 30th. As would the powers to be able to enforce the executive orders like Executive Order number 38, which by its terms and by its language purports to go until June of 2020. We believe that is beyond the powers of the governor to enact in that respect. The only last law that would provide arguable basis and has been cited by the Attorney General's office is the Emergency Powers of Governors Act, what I just call the Emergency Powers Act, is what I call it for short. That is the older law that was enacted in the 1940s and preceded the emergency management law. Now I'm presenting to you two arguments two arguments for your consideration as to the emergency powers law, the 1940s law. The emergency powers law is a more general and more vague grant of power compared to the Emergency Management Act. And it is a well-established rule of statutory interpretation that the newer and more specific act controls over a general, more older or more general act. So I would read, and I would ask this court to read, that the Emergency Powers Act is in pari materia with the Emergency Management Act, and the two acts need to be read together and impose the same 28-day deadline, which now has not been extended by acts of the legislature. Now, assume you disagree with me on that aspect and say the two laws are actually separate grants of power that should be treated separately. The governor, under the Emergency Powers Act, does not have, and I'm going to read the language, excuse me, as I look aside here, because I want to get it correct. It has the Emergency Powers Act provides that the governor may promulgate, which has a specific term, reasonable orders, rules, and regulations. It does not give the governor the authority to amend a statute, which is what she has done by issuance of 2020-38 by amending the FOIA statute going forward. In addition, it is not a reasonable rule to violate the constitutional separation of powers. Again, I would point this court, as I did in our briefs, that the power of legislating belongs to the legislature, which is Article 4, Section 1, which is vested solely in the Senate and the House of Representatives, except for the two exceptions that are listed, which neither of those are applicable in these circumstances. The power to an executive, of course, comes from Article 5, Section 1 of the Michigan Constitution. And of course, I also pointed out in my reply brief, which was accepted by this court, Article 5, Section 8 provides that the governor does not have the authority to legislate, but in fact must take care that the laws be faithfully executed. So it's the governor's responsibility not to amend the law, but in fact to obey it and execute it. And the bottom line is the governor, under the three bases that have been asserted by both publicly, by public statements of the governor during her fairly regular press conferences, as well as the briefs that have been provided by the Attorney General's office, the governor simply does not have the ability to amend the FOIA statute to create a new FOIA regime to be able to answer discovery, or to be answered to discovery of documents for public access for information. Now, I'll note in the last part here that I'm not saying, Judge, that the government itself cannot change the laws of Michigan to change the deadlines or change the obligations of local or state entities to give out records. That power exists with the state, and I'm not disputing that. My challenge here is who may exercise that power. And it's as I've outlined above, the governor does not have that authority. If she needs that authority, there is a process in place to be able to do that. And that is, she makes a request to the legislature either to extend the emergency under the Emergency Management Act, or request that a new bill be drafted and the FOIA statute be amended by a vote of the legislature and signed into law by the governor, as would any other normal bill in any other normal circumstances. The legislature is not on the run. We're not being invaded by a foreign power where the legislature can't convene. I've seen my own, and I think this court could easily agree that the legislature is sitting in Lansing as needed and can quickly pass any laws that are necessary to protect the health, safety, and welfare of the citizenry. So bottom line is this, is that the governor does not have the authority to issue Executive Order 38 anytime after April 30th, which of course is where we're at right now. So we would ask the court to issue a preliminary injunction at this point in joining the governor solely for purposes of this case, and for the narrow relief that we're specifically seeking this case is to enjoin her powers to amend the FOIA statute. On a final note, Judge, I will say that this is not merely an academic exercise, as I point out in my brief. My client, Mr. Gilman, has been harmed directly by the governor's executive order because he cannot get access to information that he needs relative to a very controversial set of decisions by the Kent County Health Officer named Dr. London, as well as a decision by the Chief Judge of the Kent County Circuit Court, and I've outlined those as being the issuance of a general warrant. He still, to that, I confirmed this morning here that there is no records have been supplied, nor has there been a formal response granting or denying the request in full. So I think for the reasons that I've outlined both in our briefs, both the motion as well as the reply brief and oral arguments today, that likelihood of success is extremely high, if not well established. In addition, the fact that Mr. Gilman wants to be able to go to Kent County and does not know whether or not he's subject to this general warrant, which is and I don't know how else to say it, blatantly unconstitutional roving warrant that exists in Kent County. He would like to be able to know what his obligations and rights are, and if necessary, to bring an action to prevent him from being unduly arrested or potentially arrested for a general warrant that currently exists. I leave this court with the final thought is that access to information is important when times are easy. It's even more important when times are tough. And right now, people need the best possible information from their government, and suspending a law that provides access to that simply because we can should not occur, I think, as a general policy. But policy questions are not for this court to decide. But what they are structured, and as our Constitution is structured, it's designed to be a policy that needs to be decided by the legislature and signed into law by the governor in these circumstances. I'm happy to answer any other questions that the court may have, and I would ask the court to issue a preliminary injunction as soon as possible to suspend the effect of Executive Order 38 going forward.
Okay, counsel, so I understand. On behalf of the state of Michigan and the governor, please.
Good morning again, Your Honor. To start, while Mr. Ellison started with likelihood of success on the merits, I don't think we even need to get there, Your Honor, because Plaintiff Gilman hasn't suffered irreparable harm. Mr. Ellison just ended that argument talking about how he still hasn't received these documents. But to the extent there even has been a FOIA violation in regards to his FOIA request, which occurred on April 18th, he has an adequate legal remedy elsewhere, and that's in Kent County. He could bring a FOIA action there. So I think on that basis alone, this motion has to be denied. But if we move into likelihood of success on the merits, plaintiff's first argument, it seems, is that EO 2020-38 is somehow limited to the pendency of the state of emergency or disaster. But nothing in the EMA provides that upon the termination of a state of emergency or disaster, that the governor's previously issued executive orders terminate as well. In fact, by the plain language of the statute, the only order that must terminate is the executive order or proclamation declaring the state of emergency or disaster. And I think this is further supported by the two sections below that, which provides that in addition to the general authority granted to the governor by this act, the governor may, upon the declaration, do additional other things. And quite frankly, this makes sense in light of the governor's responsibility under the act, which is no small responsibility. She has to cope with the dangers to this state and to the people of this state presented by a disaster or emergency like COVID-19. And again, this all makes sense because the dangers caused by an emergency may continue after the state of emergency or the state of disaster ends. In regards to plaintiff's second point, that the FOIA request, or generally that FOIA requests, would not prevent, hinder, or delay action in coping with the disaster because the defendant's office is not subject to the FOIA, I think as a preliminary matter, I would hope that we could all agree that social distancing at this point is imperative. The UN has recognized that, the CDC has recognized that, the President of the United States has recognized that. So to say that fulfilling FOIA requests, which in this case especially would require in-person efforts, doesn't prevent, hinder, or delay necessary action in coping with this pandemic, I think is quite unpersuasive, Your Honor, especially given that over 45,000 Michiganders have been diagnosed with COVID and over 4,500 have died. Second, Your Honor, neither the EMA nor the EPGA, and I'm sorry, these acronyms are awful, limits the governor's authority to take actions that would only affect her office, which plaintiff puts forth in his brief. She's responsible for coping with the dangers to the entire state and all of its residents. And finally, Your Honor, and to that point, in addition to her general authority under the EMA pursuant to MCL 30.405 sub 1, the governor can direct all other actions which are necessary and appropriate under the circumstances. And I think in this case that the FOIA EO 2020-38 satisfies that. And finally, Your Honor, plaintiff's assertion that under the EPGA, the EO in this case is not.
Do you have anything further?
One final point, Your Honor. He has said that EO 2020-38 is not reasonable because at times of emergency, people need access to records. And EO 2020-38 recognizes the importance of giving people those records. It says so right in the order. But it also recognizes that in-person efforts have to be limited to save lives. And I think that's especially reasonable in the light of several government offices, especially in rural areas, are staffed by vulnerable people. So having those vulnerable individuals who work for our state come in to fill FOIA requests, I don't think that's reasonable, Your Honor. And I think for these reasons, we would ask this court to deny plaintiff's motion. Thank you.
Anything in reply, sir?
Yes, Your Honor. Very briefly, I would point out that 2 points. One is the Assistant Attorney General in making the arguments has suggested that this is not a ripe case, and I would point the court to Exhibit C to our motion for a preliminary injunction, which points out that the County of Kent has completely adopted and is actually in their actions thus far, which are undisputed between the parties, has shown that they are following Executive Order 38 in its entirety. So to say that there's been no harm in this respect is simply not true. The problem here is not the fact, at least for purposes of this case, is not the fact the FOIA was unfulfilled. It's that the fact that the governor has amended the FOIA Act without the proper processes that governments require. Governors, I get it, governors want to be able to protect the health, safety, and welfare, but their powers are constrained. And the reason why we have constrained powers, of course, is that we have separation of powers. And I would point to, again, as I pointed on the brief, Article 3, Section 2 of the Michigan Constitution expressly prohibits the governor from exercising any legislative power unless specifically provided by the Constitution. If she believes, as the governor believes, that the health, safety, and welfare of individuals in fulfilling FOIA requests, which can be done by sending one person into the office to get copies of records, and especially when you deal with the issues that have been presented by this particular FOIA instance, that it simply cannot be a basis going forward as not a reasonable regulation or a constitutional one. Finally, Your Honor, I would point out, as I pointed
Counsel,
out,
may I ask you a question, please?
Yes. Yes.
What is it that limits your access to the Kent County Court, which is not governed by the EO?
Well, arguably, we do have access to the court. The problem is that the executive orders are being expressly and publicly announced as being followed by Kent County, both on their website, which is Exhibit C to our petition or to our motion, as well as their actions themselves and their letter back indicating they're following Executive Order 38. The Kent County does not.
Counsel, that's not what I asked you. I didn't ask you that. I said, what limits you to access to the court, which in turn, as an independent agency, can make a determination that the Kent County executive branch's interpretation and implementation of the EO is in some way inappropriate.
My belief would be is that you're seeking a declaration as to the governor's authority in that respect, and that would fall within the Court of Claims jurisdiction under
That wasn't, I understand that it would be up to me to declare the act to be void, the EO to be void in its entirety, should I be convinced. But relative to your client and your client's request to injunctive relief, the ripeness issue has to do with whether or not your client has perfected whatever rights he may have at the Kent County Circuit Court level. You've acknowledged that he has access to the Kent County Circuit Court, that you've not gone to them, and that you have relied, I think, on the assertions by the executive branch of Kent County on their website and otherwise. Did I misunderstand?
Yes, and I would point the court to exhibit number D of our petition, or of our motion, where the executive of that office has strictly relied upon the executive order to not basically fulfill any FOIA request. This case, Judge, is not about this particular FOIA request, because we plan because essentially the circuit courts have been closed by the actions of our Supreme Court, and access to the circuit courts is very hampered these days.
Actually, no, they are not closed, sir. Sir, the courts are not closed. And in fact, the courts are open under an AO that talks about the priority of action and does afford individuals access to the courts for emergency and injunctive matters. Our colleagues are sitting and hearing them. For the purposes of whether or not courts are open, while I am elected as a Court of Appeals judge, I sit as a court of claims, which is in essence another trial court. So just as you can get a hearing on an injunctive order with me, you can get a hearing on the injunctive order at Kent County. I'm not suggesting that whether or not your action and your claim in general might be valid is determined by whether or not your clients have gone to the circuit court. I'm just suggesting that the ripeness of the request for injunctive relief as relates to this particular plaintiff is in fact substantially framed by whether or not this plaintiff's case is ripe for adjudication preliminarily. And I think those are different. Whether I rule in your client's favor for injunctive relief or not, your case survives. And the issues that you frame, whether that particular executive order, which addresses FOIA, is beyond the scope of the governor's powers, would remain and would have to be adjudicated on its merits. There is no question about that.
In response, I would say this, Your Honor, the issue in this case is not the FOIA request of Mr. Gilman and Kent County itself. This case has been presented.
That's the issue that you're presenting right now, is the injunctive relief on behalf of that particular client. Your broader issue, I understand, but this is a hearing on an injunction arising out of a immediate threat of irreparable harm to a particular person, based upon that person having a request for FOIA relief, the denial of which would occasion him exceptional and irreparable harm, i.e. the threat of arrest. Isn't that what you're asking me for on behalf of this one individual for this injunctive relief?
I think I respectfully disagree, Your Honor. What I'm asking for in this case is what I'm asking for in this case, Your Honor, is that the claims that are made and the irreparable harm that is being suffered is the inability to have access to the statutory right of FOIA, generally speaking. That's the harm that's being asserted. And the example for the—
You didn't ask for a general injunction. You only asked for it on behalf of one of your two clients. So I have to look at that one client's injury.
Correct. And the injury that—
And I have to find that there's an immediate threat of injury to that particular client.
Correct.
I understand your position. We just don't seem to agree on it, but I understand it. Is there anything more you want to share?
I would like to point out, Your Honor, I think the question that you somewhat jumped me ahead a little bit from what the other response I was going to make in response to the Attorney General's Assistant Attorney General's argument is that the issue of this particular FOIA request goes to whether there is current harm in this, not whether that goes to likelihood of success on the merits. And I think we've somewhat had that discussion just now. The issue that's before you in the likelihood of success is the general claim itself, is the suspension of the statutory right by actions of the governor that does not exist in law. But the irreparable harm portion is the part that he has presented an actual example of this, and it was not a hypothetical or otherwise abstract violation of the law, but in fact he has suffered directly as a result of the executive order itself. And so I guess that would be the distinction. I think we've somewhat discussed that, and maybe we're on different wavelengths in terms of that analysis, but I think those go to different aspects of the different prongs of whether a preliminary injunction should issue or not. This case, the preliminary motion as I presented it to you goes to governmental power, not to whether or not there's a FOIA violation in and of itself. And I other than that, I have nothing further to add at this particular point.
Okay, thank you very much. You will receive a written decision. Have a good day and stay safe.
Thank you, Your Honor.